Hi, I'm Brett Bueltel. I'm an assistant professor of accounting at the University of Southern Indiana, and I wanted to update you on a conference presentation that I just gave recently. I attended the American Taxation Association conference in New Orleans, and I presented my research paper there, and it's titled "A Legal Analysis of State Tax Policy for Online Sales, the Recipe from Direct Marketing." And in the paper, my colleague and I are researching different types of state tax policy that states have implemented to try and get tax revenue from online sales. And we provide a brief overview of the history of online sales. The most recent Supreme Court case was in 1992, the Quill decision, which dealt with an out-of-state retailer selling it to North Dakota, selling office supplies, and the Supreme Court held that it was unconstitutional to require an out-of-state retailer to remit sales and use tax if they don't have a physical presence within the state. And that has been the law since 1992, and states have struggled to try to get tax revenue from online sales, and as you can imagine, since 1992 a lot of things have changed. E-commerce has exploded with companies like Amazon, Overstock.com, Wayfair. Lots of companies are selling online without a physical warehouse in the state, so states are struggling to get tax revenue from these types of transactions. And we go through a bunch of different types of state tax policies that have been implemented since states can't directly remit or require companies to remit sales and use tax. They've tried some interesting strategies in light of the Quill decision, such as a click-through law, where if you are partnering with a company that's in the state, an online company in the state, and you've got advertisements on that company's website that click through to the out-of-state company's website, then the online company can be required to remit sales and use tax under that setup. So that's why they call it a click-through law in states like New York and Illinois, and other states have implemented those laws. But the law that we focus on a lot in the paper is Colorado's notification law, which is a unique approach. It's an approach that really hasn't been tried, and it didn't go up to the Supreme Court. The Supreme Court denied cert, so they didn't agree to hear it, but it went up to the Colorado Supreme Court and it was upheld as constitutional. Essentially what the notification law is, instead of requiring companies to remit sales and use tax directly, online companies are required to notify the state government of Colorado and purchasers about their tax obligations, because that's one of the tough things about use tax. It's up to the individual consumer to report use tax, and a lot of people don't know about that obligation. So if you buy something out of state and don't pay sales tax on your tax return, you're supposed to remit use tax on that item, and a lot of people don't know about that, so it's tough for governments to enforce. But this notification law requires online companies to notify the state government of these individuals and the individuals themselves of their use tax obligations, so it makes it easier for state governments to enforce the law. And the state government passed this law, and it went up to the Colorado Supreme Court, and they upheld it as constitutional. They said it doesn't violate Quill, where Quill requires a physical presence within the state in order to collect sales and use tax. But the Colorado Supreme Court said this isn't collection, this is just notification. So the Quill decision really doesn't have any effect. And we went through a lot of different analysis about if it's effective and if it's constitutional, and we came out with a decision that the Colorado notification law, as it stands right now, is the best approach for states to use to collect tax from online transactions. Now, there's a Supreme Court case that just was granted cert that's going before the Supreme Court, which is a direct challenge to Quill. The case is titled Wayfair because Wayfair is one of the big companies that is involved in the case, and it's going to be going before the Supreme Court in April. Could have a decision as soon as June. That could change a lot of this jurisprudence that has since the Quill decision. So the taxation of online sales is a very dynamic area. Things are constantly changing. So we think this paper is a good display of some tax policy ideas that could be implemented by legislatures across the country to try to bridge the gap between that lost tax revenue from online sales. So hopefully you found that interesting. I just wanted to update you on the research that I'm doing, and I appreciate USI allowing me to go to that conference and get some valuable input on my paper. So thank you everybody, and everybody have a good weekend.